Everyone here? Okay. Well, my name is Josh Swanson. I'm an attorney at Vogel Law Firm in Fargo, North Dakota. But I'm out here in western North Dakota quite a bit between Williston and Stanley and Minot and Watford City doing oil and gas. Work is a substantial part of my practice, and this morning I want to talk with everyone a little bit about oil and gas practice issues in North Dakota, particularly from the standpoint as a practitioner, the issues I'm seeing day to day on a recurring basis. If you have any questions while we're going along, absolutely feel free to ask. You don't have to save them to the end. Just feel free to interrupt me, and I'll try to get through as much of it as I can here. How does an oil and gas lawyer start their day? Well, some days it feels like this because just like we don't have enough judges and staff to deal with oil and gas issues, we certainly don't have enough lawyers, and it's not unusual a lot of times for something to take, I'll tell clients that call me, I'd love to help you, but it's going to take me a couple weeks or even a month to get to something. So some days that's what it feels like. Most of my clients are great, but it's a very, very busy practice area, and we absolutely, for the law students in the audience, we do need more oil and gas lawyers in North Dakota. Hot topic, legal issues. Family disputes are something that we're seeing quite a bit over mineral rights, and a lot of families, being in North Dakota very family oriented, what's one of the most disappointing things to me, having clerked for the judges in the Northwest District and having practiced in the area now for several years, is that when you start talking about mineral rights and interests, it literally does tear a lot of families apart, and it's a big source of litigation that we're dealing with as practitioners. Curative title issues. It's not unusual to get a call from a client who has a deed from great-grandma or great-grandma from 1953, and they've got, 5 or 6 kids who have had 3 or 4 kids, and some have been deceased, and there's been no probates done. So when the oil company starts production and they need to figure out who to pay, that title opinion will say you need to take certain steps to clean up that title so we can pay you. And we'll talk about different areas or different means to do that, but that's an issue. Obviously, the dispute between the mineral owners and the oil companies. And a big source of this is leases. We don't have enough rigs in North Dakota to drill all the wells. So right now, we'll get calls every day from mineral owners saying, hey, look, I signed a 3-year lease on March 15th, 2010. Well, it's 2013, that 3 years has gone by. I've asked them to release my lease, and they won't do it. So that's a substantial source of litigation that we see. Disputes between surface owners and oil companies and surface use agreements. And I just heard Wade and John here talking about drilling from outside of a spacing unit. And that's something I have a landman, I don't know if he's here, and he's a nice guy, but he's emailing and calling me back and forth all the time, and they're very, very anxious to start drilling. And I need to take a look at those agreements and confer with my clients before I say it's a good idea. But it's one of those situations where as a surface owner, they have more leverage because the company wants to drill from outside the spacing unit on their land going north. So I think, the surface owners in Section 4, they want to drill north into Sections 28 and 33 into that spacing unit. But obviously Section 4 south of that isn't in the same spacing unit. Abandoned mineral claims, and I know some of the judges in the Northwest District are big fans of these. They're not big fans of them. As an attorney, we see these all the time. We have surface owners who are calling us saying, I don't know if anything's being done with these minerals. And in fact, last year I had an attorney from Missouri call me up who represented some consortium of surface owners. And their firm in Missouri, they went out and solicited as many surface owners in North Dakota. They had sent attorneys up to the courthouses and to look at title and figure out what surface owners might have a claim. And then they go after these folks and say, we'll take this case. We'd be happy to do it so long as you assign us part of the royalty. So then they called and asked us to try to get some title work done on it. So that's a very common issue. One of the unique things about oil and gas agreements, particularly leases, as a practitioner, as an attorney, we're governed by the four corners rule, right? If something's in the contract, that's going to control. Oil and gas leases are a little bit different and unique in the fact that there are certain implied covenants in every oil and gas lease, meaning that these things aren't written down in the leases. They weren't bargained for, they're not a part of it, but they're part of those leases, and it becomes frustrating. From a mineral owner standpoint, it's great because you can use those in some situations to maybe leverage better terms if your lease is coming up on expiration, or if you say, you know, hey, my grandparents signed this lease in 1979, the bonus was $100 an acre, and they're getting a 15% royalty. You know, there's production, so that lease, if there's production on the acreage, the lease is HBP, or held by production. Well, these implied covenants are a counter to that, and the problem, having worked or doing work for several oil companies, whether the oil company has breached the implied covenants, it's governed by what's called the Prudent operator standard, and that's a question of fact. And for you lawyers in the audience, you know that a question of fact means we're not winning this on summary judgment. We're going to have to do a bunch of discovery. One case, I think it's a Soren v. Olson case from North Dakota, frames it as a battle of experts. And in fact, I think it's the Olson case. There's a great dissenting opinion by one of the judges saying, this is nuts, we're reading these implied covenants in here. Why are we even looking at implied covenants? But that's become an issue, and if you're doing a bunch of fact discovery, you're going to end up spending a lot of money on it. So I think from some standpoints, I have a case I'm working on right now that's set for trial where we got part of it kicked on summary judgment, but the mineral owner who's brought a claim for breach of the implied covenant of reasonable development, you know, we've probably spent anywhere from $50,000 to $100,000 litigating this because it's a fact issue. Environmental issues and regulatory issues. You know, I heard the attorneys before talking about the industrial commission, and if any of you are from the Minot area, you remember the flooding that went through a couple of years ago. That water got into a bunch of reserve pits, and some contamination occurred. So operators are getting these nasty grams or candy grams from the State Department of Health saying, oh, by the way, we're going to fine you X amount of dollars. So those are some of the regulatory and environmental issues that are coming up. And obviously you have your personal injury cases. You pick up the Williston Herald, the Minot Daily, and it's not unusual to see in every, weekly at least in those papers, someone getting killed in a collision with a truck out there in oil country, or someone, getting severely injured in an accident on a rig. Criminal cases. Funny story, I was in Stanley here in November for a hearing, and you can't go, if you want to make a good living, if you're a law student outside, if you have no interest, you're thinking, well, I don't know if I want to do oil and gas, you can make a good living by being a criminal defense attorney just by showing up in a suit to these courthouses on a lot of days. I was in Stanley for a hearing on an oil and gas matter. I had at least four people come up to me asking me to be their attorney in a criminal matter, and I remember being in Williston for another hearing on the master calendar days where they haul all these defendants in for a preliminary hearing, and they're literally lining the hallways both sides of the courtroom, and I got swamped with requests, and I'm thinking, forget oil and gas, I'm gonna be the Western North Dakota Bruce Quick and start doing criminal practice, and they'll pay cash on the spot. So you see a lot of that. And an area I think that we're going to start seeing in a couple years is a lot of class actions. And you're starting to see some of this in Oklahoma and Kansas, where mineral owners are taking a look at their checks and saying, hey, wait a minute, these numbers aren't adding up for royalties. And several oil companies have had to pay out substantial settlements in these class actions related to that. And I think that's something that's, if it's not coming in the next year or two, some attorney's going to get wise to it and say, let's try to make some money on this. So I think that's something that's coming down the pipeline as well. I don't do any of it, but I get enough calls from clients who are saying similar things to what the plaintiffs were saying down in Oklahoma and Kansas and Louisiana. So I think that's coming. Document drafting. Whether you're an attorney, a landman, or a business person, or anyone involved in the oil and gas arena, it's a very document-intensive practice. Whether we're talking about leases, surface use agreements, statements of claim, deeds, creating a trust or an LLC to manage the minerals, curative title documents, whether that's the quiet title action or a stipulation and cross conveyance. notice of termination and forfeiture, an affidavit of validity and effectiveness, the settlement agreements, estate and succession planning and transactional. I mean, the oil boom in western North Dakota has really been a boom for attorneys practicing in the area, and these are documents that if you are practicing, you're going to come across them every single day of your practice, and you can make a very good practice doing it. So why so many lawsuits? Well, I've come up with what I call the Bakken Equation. That's property plus minerals equals a lot of money, right? And so if you do the math here, talk to one of the judges in the Northwest District. I mean, having clerked for them, I can certainly understand, and practitioners as well. Lawyers are busy, but there's a lot more of us than there are judges and judicial staff, and even clerks in the county recorder's office. You send something in to Montreal or McKenzie County to get it recorded, and it's going to take a couple weeks just because there's such a backlog there. And I think the legislature, the proposal is to add 2 judges in western North Dakota, and if there are any legislators in the room, this is something that's desperately needed. I know that for cases that we've had going on, just to get an hour or 2 in front of a judge out in western North Dakota, I mean, you're talking sometimes 3, 4, or even 5 months if you need to schedule something, and you just need an hour or 2 for that. So we could definitely use more resources. That's absolutely for sure. And outside of talking about the Bakken Equation, I'll tell you something we hear every day, and I think that's why, I know it's why people are fighting about it. So someone calls my office and says, I've got 320 net mineral acres under a lease, and I signed it in 2008, and I have a 5-year primary term. Okay, so that primary term's coming up on expiration here in 2013. Well, back in 2008, the financial terms, whether it's a bonus or a royalty, they're not anywhere near as good now, especially for areas where there's a lot of exploration and activity, right? So you have mineral owners calling and saying, hey, I leased these in 2008. My neighbor Frank leased them last year. He got a $2,500 per acre bonus. I got an $800 per acre bonus. What can we do about it? The first thing we do is we take a look as attorneys to see if there's production, because if there's production, how these leases work is there's a primary term, and let me kind of backtrack for a minute, because as attorneys we kind of get the idea that everyone assumes what we're talking about, and a lot of times that's probably not the case. But for leases, for those of you that aren't familiar, how they operate, there's two time frames to them. There's a primary term and a secondary term. Okay, that primary term is typically 3 to 5 years. And during that primary term, there has to either be production, so oil coming out of the ground, or operation, some sort of drilling activity that occurs within that 3 or 5 year span. And if there's no production and no operations going on, then that lease terminates. All right, from the mineral owner standpoint, that can be a good and a bad thing. When you sign a lease, obviously you hope there's production so you can get a royalty. From the oil company standpoint, there's not enough rigs, right? So they have to prioritize their leases, and if those leases expire, they're probably going to have to pay out another bonus on top of what they paid previously. They're probably going to have to pay an increased royalty. So that's when we start talking about the money piles up, because the oil company is not going to want to write another check to the same landowner for another bonus. They probably don't want to increase the royalty. And at the same time, the mineral owner, understandably, is getting antsy, saying there's no production. I want to, my neighbor got a $2,500 net acre bonus. I want to get that. So you really have 2 forces pulling in opposite directions. And I think because of the uncertainty, and we'll talk about some of these issues under the leases, what is drilling operations? What constitutes drilling operations? That's a source of dispute in a lot of lawsuits I have right now. I say, staking and permitting and surveying a well, are you kidding me? That's not drilling operations. You don't have anything put into the ground to get oil out. Well, the oil company takes the opposite approach, saying, well, we've built an access road, we got our permit, it's staked, it's surveyed, that's operations. Well, for them, there's a lot of uncertainty there, but same with the mineral owner. So in a lot of these cases, the middle ground is to negotiate and say, okay, you increase our royalty by X%, we'll drop a suit and we'll agree to a modified lease where you extend the lease for so long. But there's also a lot of chess that goes on, right? because lawyers see this, and these oil companies have very, very talented and skilled lawyers. So some things they're starting to do, and I taught the oil and gas practice course at the law school this fall. So I'm on the front lines, kind of seeing what the oil companies, dealing with a lot of them day to day. They're putting option clauses in these leases, saying, okay, this lease is for a 3-year primary term, but we reserve the right at any time to offer you, $200 or $300, just a very small amount per acre. And just by doing that, you don't have to accept it. All we have to do is tender payment. And by doing that, that operates to extend the lease for another 2 to 3 years. And these leases are fine print, and they're always boilerplate. So it's tempting if whether you're a mineral owner going over a lease, or if you're an attorney like myself who reads, dozens of leases a week, your eyes can start to glaze over, but it's important to pay attention, like I tell my students, because if you don't catch that option clause, and you tell your client, well, I think we're fine, let's sue them out, so you file your complaint, then the oil company comes back and says, hey, wait a minute, take a look at paragraph 16 here. We did that. You don't have a case. And you have to go back to your client and say, yeah, I just wasted a couple $1,000s of your money because you don't have a case. So it's kind of a constant back and forth, and we'll talk about that in a little bit as well. And like I mentioned, we absolutely need more lawyers. If any law students in the room, if you want to make a good living coming out of law school and be very, very busy, work in a challenging environment, and get to take on some serious litigation and responsibilities right away, oil and gas is definitely an area. I can't say it enough. We absolutely need more lawyers, and lawyers, including myself. And we turn work away all the time. You can't get to it. There's too many phone calls coming in, and you get calls from people that have attorneys in Williston or Dickinson and Minot, and they say, well, I got this to them 3 or 4 months ago. They haven't done anything. Can you take it? And I say, I'd love to, but I can't, because I probably can't get to it for 3 or 4 months. Some of the basics here. And I'm going to start with leasing. I'm going to just kind of go over some of this real quickly, because I caught some of the other attorneys talking about it. The mineral estate is separate from the surface estate. And the mineral estate is dominant, which means in most cases, so long as something's within that same spacing unit, the mineral owner or the mineral operator and developer can come in and do whatever they want. And this is obviously a source of a lot of tension in western North Dakota, where you have a surface owner who's got a farming or ranching operation, and the oil companies come on, and if it's in that spacing unit, they can put the rig up wherever they want. Now, I will say, having worked for oil companies and mineral owners, most of the companies in North Dakota, I think, do a good job working with the mineral owner and trying to reach an agreement, a surface use agreement. And I have a company that I work for that they're almost always hesitant to proceed without one, because they don't want to get the reputation as being a company that's going to go in and run roughshod all over surface owners' rights. And here's a hypothetical. This is something that this phone call comes in at least 3 times a week. Okay, the client's been offered a lease, and the terms that are being offered are $1,000 per mineral acre and an 18% royalty. So let's assume the person says, well, I own 320 mineral acres, which is half a section, and which is actually quite a bit. They're usually smaller than this, but this math is a little easier and I think makes the point better. So if you do the math in your head, 320 mineral acres times $1,000, now that's a $320,000 bonus just for signing that lease. A drop of oil hasn't come out of the ground yet. You're just signing the lease. And for most people, myself included, that's a heck of a lot of money. And why would you not sign that? If someone puts a $320,000 check in front of my face, I'll do a lot of things for that $320,000, right? So when I tell clients, well, wait a minute, they look at me like I'm crazy. Are you kidding me? They want to give me a check today for $320,000. But is it worth it, right? And this is happening every single day in living rooms from, Crosby to Williston to Watford City to Arnegard and everywhere in between. So would you sign the lease? Anybody out there, if the oil company comes to you and says, you know what, you have 320 acres, and we're going to give you, not only are we going to pay a part of it that comes out of the ground, we want to give you 18%. 18% of what comes out of the ground, we want to give that to you, but just because we're such great people, we're going to give you a bonus check for $320,000. Would anyone say absolutely and sign that lease? Anybody? No? You're smarter than some of my clients. Because a lot of people do. right? Because it's a, generally it's a good thing. Someone wants to pay you to produce these minerals. Well, before you sign on that dotted line, there's a lot of things to consider. And like I had mentioned, an oil and gas lease is unlike any other lease you've probably dealt with before. And in fact, there's a Supreme Court of Texas, they've had cases that say that, in fact. And I think we cite one of them in here. But what are you getting when you sign the lease? There are some leases that have been, I know in cases I have going on right now, the well's been producing since 1979. And my client's grandparents signed that lease, and the terms then compared to now are pennies on the dollar. There's also not a pew clause in a lot of those leases, which we'll talk about in a minute. They agreed to warrant title, so they didn't even do the title opinion. It says in there that the mineral owner will warrant and guarantee title that they own it, but it's the oil company who did the title opinion or paid to have the title opinion done. So what they're saying, and that's something that if you ask to have it taken out, every time, whenever I see it in there, I tell the landman, we need to get this out of there. They never object. And in fact, I had one landman tell me in a deposition, there are 3 things we'll always agree to put in or take out that we don't need approval on. One's warranty of title. If you ask us to take it out, we will. Not everyone does that because they see these numbers and they think that's a hell of a deal. Okay, but then they get stuck. I have a case going on right now where one of my clients, we have a suit against an oil company. They signed the wrong person up for the minerals. My client owned the minerals, or at least that's what I'm telling the court, saying these deeds are pretty apparent. This foreclosure deed is crystal clear. This guy didn't own the minerals, and the oil company leased it anyway, right? Well, the mineral owner who signed that lease, he warranted title, and he guaranteed that he owned them. So now, regardless of how the suit comes out between my client and the oil company, you can bet that bonus money the oil company is going to go after the guy they thought owned the minerals because he warranted title. Now, he might be judgment proof and might not be able to pay it back, but he wouldn't even have to worry about that headache if he would have crossed that out. Are the bonus and royalty offers fair? And I'll tell you, a great tool for practitioners. The Industrial Commission does a fantastic job of making this information available online, and in real time too. One of my favorite things to do, and not to pick on any landman out there, because there's probably more of you than me, and I don't want to meet you in the parking lot. That I love getting calls from landman, and they've given an offer to my client, and they say, and I don't know if it's a script they work off of, and I know you have a job to do, but what I hear all the time is, this is what we're giving everybody. We can't give it to anybody else. This is what we gave John's 3 siblings. This is what we have to give him. And I say, well, frankly, I don't give a damn what you gave his siblings. They're not my clients. My client hasn't signed a lease. $1,000 is way too low for a net acre bonus, and a 15% royalty is absurd. And some of them say, well, there's not much going on in that area. There's not much drilling, not more exploration. Well, we can hop on the Industrial Commission's website. I can plug in the township, the range, and the section, and it'll pull up a map with every single well that's drilled on that piece of property or around it. So I can say to the landman, well, I'm taking a look at that township, and I see 30 wells there. He says, oh, well, some of those are ours, some of them aren't. I say, well, I can pull up well number 17131, and that bad boy is cranking out 15,000 barrels a month. So I said, you guys are going to have to do a heck of a lot better than a $1,000 bonus and a 15% royalty. And they agree. But, while I have a job to do representing mineral owners, their job is to make as much money as they can for themselves and their clients. And the way they do that is by signing mineral owners to terms that are more favorable to them. But that's something, if you get offered that $1,000 per acre bonus, and it's an area where the market rate for a bonus is maybe $2,500 or $3,000, and the royalty is more like 20%, you're leaving a lot of money on the table. A force majeure provision is something that we're starting to see quite a bit as a rationale for, we'll bring a claim or write a letter to an oil company saying, I think you're in breach of this lease, and we'll sue it out. And one of the affirmative defenses we hear back all the time is that force majeure applies. And the force majeure means, it's an act of God clause, labor shortage, equipment problem, and it all depends on how broad those force majeure clauses are written. So if you're a mineral owner and you just sign that lease and the force majeure clause is broad as a truck, where it says something, anything and everything beyond our control. If there's a delay in permitting, if our workers get sick, if our trucks get slow. I mean, if I'm the attorney working for the oil company, I make that force majeure as broad as possible with the eye to the fact that we may need to use that as a defense. Now, if you're a mineral owner and you agree to that, you can get stuck holding a lease for quite a while or find yourself in litigation when you could have addressed it on the front end. Same thing with the warranting title. And then who's on the hook for damages? I mean, there's a lot of issues. If you can define it in a lease, go ahead and do it, because you might save yourself a lot of headache and costs by foregoing litigation down the road if you have something in that lease. Mineral owners aren't required to sign a lease, and I think I heard Wade talking about that earlier. Under the Century Code 380808, they can sign the lease, they can elect to take a working interest, or they can go non-consent. And that's something, in fact, a lot of times I use that as leverage when negotiating with oil companies, saying, you know, if you can't do any better on these terms, my client will go non-consent, or if they have the money available and they're, you know, I'll say they want to take a working interest. And the oil companies don't like that. They'd rather sign the lease. So that's something that gets used as leverage, but that's something that's available to the mineral owners as well. There's a couple cases. Their oil and gas leases, they're unique, but they're governed under the principles of North Dakota contract law, and that goes back to that Eglin case that Wade had cited. Leases are not, oil and gas lease is not a typical lease, so if you're a farmer and you're doing sharecropping or you're leasing your land, an oil and gas lease is a lot more complicated, a lot more complex. There are a lot of moving parts, and those parts interact with each other. And how they do that, something we're just starting to see now. You know, one of the clauses in a lease is a pew clause. And how that pew clause works, let's say you have in that township up there, okay, there's my client. Let's say my client has a lease that covers sections 1 and 12, parts of 17 and 20, parts of 23 and 26. All right. Now, like the guys that just mentioned, typically there's 1,280 acre spacing units, right? So 1 and 12 would be a spacing unit, 13 and 24 would be a separate unit, 25 and 36 would be a separate unit, and the same going right to left across the map there. Now, generally, if you have a lease, the general rule is oil and gas produced anywhere from the lease is going to operate to hold the entirety of that lease. Meaning, if you have an interest in 6 different sections and they're all in different spacing units, production anywhere in any of those spacing units is going to hold your lease unless you have a pew clause. What a pew clause says is that production within a unit only holds the lease as applied to the acreage in that unit. So let's just pick out 2 sections. Let's say I have oil and gas in 25 and 36. Okay, sections 25 and 36. That's spacing unit 1. And I have oil and gas. My lease is for 25 and 36, and then for sections 1 and 12. Sections 1 and 12, that's a separate unit. Now, if there's production or activity in sections 1 and 12, that'll hold the lease as applied to 1 and 12. But with the pew clause, that releases, if there's nothing going on in that unit, that's 25 and 36. 25 and 36, those sections of my lease won't be held because of that pew clause. Okay, now we talk about a lot of moving parts in a lease and the interaction of different clauses. Now, something that I'm starting to see just in the last few months is that we'll get a call from someone and say, hey, I got a pew clause, man, I'm golden. This pew clause gets me out, I can negotiate a new lease, I'm going to make a bunch of money. And I say, yeah, you're right. I think you're absolutely right. So we send a letter to the oil company, and that's something from a practical standpoint for especially younger practitioners. Especially myself being one of them, sometimes you get kind of hell-bent on picking a fight and litigating and being the alpha dog, getting after it for your clients. Something I always do as a matter of course before I sue it, and I'd recommend the same thing to young practitioners, because you can sometimes resolve the issue this way. I always send a letter first saying, this is who I represent, this is the issue we're looking at. If you have any information to the contrary, let me know. But this is a claim we want to bring. Please get back to me by X date. Let's try to work something out, right? So I've sent several of these letters saying, hey, there's a pew clause, guys. There's no way for you to get around this. You have to release this lease because it's undisputed. There's no operations. You guys don't have a pad. You don't have access roads. My client's been out there and taken pictures. It's an empty pasture. But there's production in other parts. And they say, well, the continuous operations clause in there operates to hold the lease because since we're still doing operations on another unit, that's going to hold the other parts of the lease subject to the Pew clause. And I say, that's nuts. You're reading the Pew clause right out of the lease. They say, oh yeah? Well, do something about it. So I think that's another one of those issues, how you go back and forth between the attorneys involved. That's a trending issue, and I think that's going to work its way up to the court, the interaction between the Pew clause and a continuing operations clause. But that's just one example of how these different parts of the lease work together and have an effect on each other. Money isn't everything, obviously, but it's pretty important. I think if you ask most people who have a lease, those dollars tend to get folks wide-eyed, and that's what they're looking at. But there's a lot more things that are going on in there that you want to be aware of, especially if you're farming or ranching, or if you have a tenant out there that you kind of want to protect their rights, whether that has to do with how close you're putting something to a well, the placement of it, water use and rights, constructions of roads or pipelines. Define these terms if you can. The worst you can do is ask for them. And I know when I'm negotiating leases, I'll ask for 10 or 15 things. Well, I know I'm not going to get all 10 or 15 things, but if I can get 5 or 6, that's still a win, and that's something you can take to your client and say, I still think this is a pretty good deal. But the more defined terms you can have in there, the better. And the more you can protect your client's rights, the better. Because if you don't, and again, not to rip on oil companies, if you don't, they're certainly not obligated to look out for your client. They're obligated to do what's in their best interest. And same with the drilling operations one. And I know there's a bill in front of the legislature right now that would create a narrow definition of that, but something we're seeing quite a bit now is what constitutes drilling operations. And I had mentioned earlier briefly that, we'll say you haven't got a wellbore in there, you don't have any equipment on the ground that's capable of penetrating that ground, taking a well out. Well, companies say, well, it's not defined in the lease. In drilling operations, there's some cases from other jurisdictions that say surveying, staking, and permitting is enough. There's other cases that say that you need to have an apparatus on the ground physically capable of taking that oil out. Well, if you don't define that, the oil company can afford to pay their attorneys to fight that. And they're going to pay their attorneys to fight it because from a cost-benefit standpoint, it makes sense to them. If 100 people call them and say, this isn't drilling ops, of that 100, maybe 10 follow up with a suit, and maybe 1 or 2 can afford to take it all the way through. Whereas a mineral owner, you have to ask yourself, if you don't define it, are you willing to risk, paying someone like me? And as much as I'll work my butt off for you and be a great attorney, I don't work for peanuts. So are you willing to pay someone like me 10, 50, 100,000 to fight this through a trial because you didn't define the term or didn't have the foresight on the front end to hire an attorney to define the term? These are just some other of the clauses: the force majeure, shutting gas, getting rid of the options, things to consider in the lease. The implied covenants, if you're an attorney or if you're a landman, I would include language in the lease saying that the mineral owner expressly disclaims any implied covenants. If I'm an attorney for the mineral owner, I want to make sure it doesn't say that. I also want to get rid of any language about a curing provision. And this is something that strikes me. Lawyers are unique people, but when you read in a lease, these curing provisions that say, okay, mineral owner, even if we've put you over a barrel bad and we're in the wrong legally and you have a claim against us, you have to write us a letter explaining what we did wrong, and then we get 60 to 90 days to fix it. And only after those 60 or 90 days, if we don't fix it, then can you bring suit. I'm thinking that's unfair. I don't like that, doing work for mineral owners. I always ask to get it stricken or cut down to 30 days because you don't want to tie up your client's property or spend more money than you have to fighting it. But that's another example of something that's in there and important. Document drafting. A lot of you attorneys practicing in the area of oil and gas, this is a big part of what we do every day. Surface use agreements. The rights of a surface owner are often limited, right? But it doesn't mean that you can't protect yourself to some extent with that surface use agreement and trying to put, whether that's a greater annual rental to yourself, a yearly payment, the more you can put in there, the better. And I'll get to some of those particulars here in a second. A big thing right now for developers and oil companies are these multi-well pads. You know, it used to be you'd put the one well in the 1,280 acre spacing, but now on one well pad, you can put, 4, 5, 6, 8, or even more wells on a single well pad, these horizontals. And if you don't, in your service agreement, put something in there saying that the oil company agrees to pay surface owner $2,000 to $3,000 per well, then if it's open-ended, I have one right now I'm going back and forth on a guy with. He says, well, we only intend to do one well. And I say, you know what? You say you intend to do one well, but your agreement here doesn't say that, which means that if you decide to come in and apply to the Industrial Commission to do 6 more wells and they grant it, they can do that, and my client's not going to get paid anything for it. So that's kind of an area we're seeing right now is you have to really, I limit it to previously identified wells or say, you'll agree to pay the $2,000 or $3,000 per well. And some oil companies won't do it, but some will. It just depends on the company. Especially for the surface owner, you want to include language very broad as far as damages, where you won't be held liable and the operator will indemnify you. And the corollary is true too. I mean, the mineral owner is going to want that as broad as possible on the flip side of it. And then limiting what can occur on the land. If it just says operations incident to oil and gas production, well, what does that mean? That means it's a litigator's heyday because we can come in, do all kinds of discovery and say, well, this is incident to operations. If you don't specifically define that or put in things like, okay, no large storage tanks, no employee quarters, no or man camps out there, no housing, expanding the well site, putting an extra cuttings pit. You have to be careful to limit that stuff, or at least try to limit that stuff for your clients. And the details absolutely matter. And something I do, I always ask, and the oil companies are usually good about providing this. In fact, they're always good, and I've always provided it when I've asked, is a map of the proposed site showing where the pipelines are going to go, the transmission lines, the access roads, the acreage where they want to put that well, burying all underground lines below plow depth, especially important if you have someone farming out there. All structures removed X days after the well is abandoned or gone, and that's something that's important to put in there on the back end of it, so you're not coming back. The well, it's a good producer, it's producing for 20 or 30 years, and it's done, right? So oil company's going to take it out, plug and abandon it, stop operations. Well, put something in that service use agreement saying that they'll agree to remediate and reclaim within, whether that's 60 or 90 days. That can help your client. Statement of claim. Kind of go over these a little bit quick. I think we're running out of time. If you don't do anything, this goes back to that use it or lose it idea of a dormant mineral claim. Every 20 years, if you own minerals, you have to do something about it or you're going to risk losing it, because a service owner can come in under Chapter 3818.1 and file what's called a dormant mineral action, saying that this property hasn't been used or these minerals haven't been used for 20 years. Our law and policy says it's important to develop those minerals because they literally drive our economy. We need them. The service owner and service owners have in North Dakota, they've gotten minerals that didn't belong to them because nothing happened to these minerals for over 20 years. And you're thinking, well, how does that happen? How people that own the minerals sleep on those rights? Well, it's not uncommon because let's take great-grandma and great-grandpa. They owned some property up by Stanley in the 1950s, right? That first oil gas boom came. The land, when they're getting to get older, it's the early 60s. They're doing their estate planning. That land's not really worth much, and those mineral rights aren't worth anything. So they're not going to take the time to take a look at those. In a lot of cases, they didn't. The mineral deeds that were out there, these leases from the 1950s, just sat until someone found them in a courthouse and said, hey, nothing's been done on this land for 50 or 60 years. After great-grandma and great-grandpa died, grandma and grandpa might be around. They might be living in Colorado or Arizona. They don't know what's going on with those minerals. They're not paying attention. They probably don't know that their parents owned it, and their kids certainly don't know. So what happens is the service owner comes upon this, and under this statute, if there's an address of record, you don't have to try to track down who the mineral owner is, right? So it's not like when Grandma and Grandpa died, the minerals went away. Even if they didn't have a will, through our laws of intestacy, they're going to go to the heirs, right? But the law doesn't say you have to try to track down their heirs. How the law works, it says if there's an address of record, all you have to do is send notice that those minerals have lapsed to that address of record. And we actually, when I was clerking in the Northwest District, we had the Swanson v. Aylander case where the Swansons, who were the surface owners, sued to quiet title for the minerals owned by the record owners, the Aylanders. Okay, that was the situation. The Aylanders acquired their interest through a mineral deed in 1953. So 50 years goes by, no one does anything about it, and the surface owners, Swanson, say, hey, this is great, let's take these minerals. They take a look at the deed, and the address says Buffalo, North Dakota. That was the address of record, Buffalo, North Dakota. Now, you don't have to run the U.S. Post Office to know if you mail something to Buffalo, North Dakota, and just put Buffalo, North Dakota on the letter. It's probably not going to get to the person you want it to, unless that postmaster's been around for 60 years and say, oh, I remember Russ and Edna and their grandkids down the road, I'll just take it to them. So that's what the Sorensons mailed the notice to. The district court says that the Sorensons failed to conduct a reasonable inquiry because how the statute reads is you have to send the notice of lapse to that last known address of record or make a reasonable inquiry. And the judge says there was no reasonable inquiry, this notice certainly wasn't, and that's a standard under the Mullane, right, that Civ Pro case, reasonably calculated to provide notice. Well, sending something to a town certainly doesn't seem reasonably calculated to provide notice. So that's what the district court says. The issue is Buffalo, North Dakota an address? And that's just the language. That's the language. If you take a look at the underlined and italicized or, that or was determinative when it went up to the Supreme Court. The Supreme Court says if you send it to the last address of record on the deed, even if that address says Buffalo, North Dakota, or Big Bird's house, that's the address of record, and you've complied with the statute, which seems goofy. It's probably it is as far as a policy standpoint and providing notice, it's probably a bad and unfair result, but that's what our statute says, and that's what happened. So it's important to be aware of things like that, and these are things we're coming across every day practicing. So how you prevent that to having your minerals lapse is that statement of claim. It's just a real simple document you file with the county recorder's office saying, my name is Josh Swanson. I'm claiming this property in Township 152, Range 100, Section 23. I'm claiming it because my grandpa had an interest in it, and he willed it to my dad, who willed it to me. This is your notice to the world. You record it in the county's recorder's office, so that provides notice to the world. So if an oil company comes in, they know you own it, and so if some service owner comes in, they know you own it, and they can't make a claim to it, so that protects your rights. And I think we have time to do the curative title issues real quick. So in those situations, this is kind of part and parcel with the dormant mineral claims or those deeds that have been out there forever. When they're the last things out there of record, the oil company still needs to know who to pay. So what they'll do is they'll track down who they think owns it, and they'll send a letter out saying, we think you have interest in these minerals, but there's a gap in title, right? Because the last thing done with these deeds was back in 1953. Your great-grandpa owned it. Now your great-grandpa has 17 heirs, and he wanted to give some property to charity, so in his will, there was a residual clause that said half to my favorite grandson, Josh, because he's great, always came to visit me, and he was a fantastic athlete in high school and all this stuff, and he's a great lawyer. The other half to the American Heart Association, right? This actually happened. I had a client who got one of these curative title letters, and his mom got property from her mom, who got property from her dad, and in the will, when they did her dad's probate, half went to the kids, half went to the American Heart Association. So we had to do a stipulation and cross conveyance, and actually I ended up suing the American Heart Association. But before I did that, I called them and sent their attorney letter. And I sent them and their attorney a letter and called them and said, the oil company wants a quiet title. You know, we have the stipulation of cross conveyance. They say it's not enough because in a stipulation of cross conveyance, you're just agreeing with another party what you own. So if it's between any of you and me, I say I own X, you own Y, we agree to that. I own these minerals, you own them, you file it, the oil company says good enough. So I called the oil company in this case, they said, nope, you're gonna have to sue the American Heart Association. So we filed our complaint, but we also did a stipulation and cross conveyance, and we incorporated that into our findings of fact and rulings of law for the court. We submitted a proposed order, and they agreed with the complaint, so it all ended up working out. But those curative title issues, you know, that's what we have to do a lot of times, is you have to actually, you know, sue some people. Another one I have right now, I have clients in Norway whose great-great-grandparents lived out by Williston around the turn of the century. They said, to hell with North Dakota, it's too cold, we're going back home to the fjords. Well, they had property up there, and no one did anything with the minerals. They still own the minerals. So now their heirs in Norway have these mineral interests, and they're the only ones that have them. So we have to file a quiet title because, the stipulation in cross conveyance and a quiet title is a lawsuit, and it's important to make a distinction. You know, me and any of you can agree to something, and that applies between us, right? It's a contract and an agreement between you and me. But it doesn't apply to the rest of the world, right? A quiet title, if you sue out a quiet title, you can name parties that have an interest, but by publishing the quiet title under our statute in the county paper of record where the land is, that's sufficient to address any unknown parties that may make a claim that aren't of record. So a lot of times I can understand where these oil companies are from saying, yeah, you know, a stipulation or an agreement would probably address it, but there could be someone out there we don't know about, so we want a quiet title. So that would be the distinction there. And that's, you know, it's just a family tree. I mean, literally it gets, you know, I have one case going on, and we had to hire a genealogical expert to try to establish heirship, and this goes back to, you know, the 1800s, documents all over Europe, a family tree like that initially with a bunch of gaps in it. So that's something that's actually happening now, and I think there's a cottage industry with these genealogical experts, and that's what you have to do in some of these cases. But it ended up being a real complex litigation that we're just working through right now. But it's a heck of a process, and that's something we're seeing quite a bit of. This is just an example of what those letters look like, and they say, you know, requirement, telling you what you need to do. And I think I'm about out of time. I'd be happy to answer any questions real quick, or take as long as you need me since I got the floor.
As an attorney who's worked in oil and gas plays where bonus and royalty have gone down, I want to challenge you. Is it wise for the attorney to advise his client as to where the market is for bonus and royalty, or should they just be directed to where that information is?
Yeah, you know, I get where you're coming from maybe a liability standpoint. You don't want to tell them it's 3,000 to 5,000 right now, and 5 years from now it's 7 to 9. I'll tell my clients what I think market is and what we're hearing, because that's what they want to know, and they'll keep pestering me. It's like when they want to sue, we get all the time, what's the odds of success? What are our chances? 5 in 10, 3 in 10? If I have a good idea, I'll tell them, because I think my role is to provide them the information they need to decide whether or not they want to sign the lease. Because what ends up happening if they have an interest in, you know, if they've got an interest in Section 1 or 12, and that's in a spacing unit, and, you know, Continental or EOG is drilling out there, they send an election letter to my client saying you have 30 days to decide whether or not you want to lease, whether you want to be a working interest owner and pay your costs up front with your share in this well, or whether you want to go non-consent. So I feel I have to give them the information to say, okay, you know, from a financial standpoint, this market is probably where we're at right now. This is what you could get paid. And for a lot of them, you know, $100,000 is a lot of money. It can go a long ways. So there are times where I've advised them, this bonus is too low what they're offering. And I put a letter in the file to back it up, and I make them sign it saying I told them not to sign the lease. I thought it was unfair. So if I know and have a good idea what market is, I'll tell them right now that's what it's going for. But I'll also tell them, right now in southwest North Dakota, there's a lot of poking around, and even in areas of Bottineau County where they're scratching around. Well, a lot of the land, most of the land, in fact, around, obviously your Stanleys and your Watford Cities and your Williston, that's going to be signed up and under lease already. So a lot of the landmen and independent landmen and oil companies, they're going into areas where it hasn't been as explored maybe, like southwest North Dakota, and they're offering the leases. But the leases, since there hasn't been as much exploration, the bonuses are quite a bit lower, maybe $500 to $800. And I'll tell them, that's probably market right now, but I'd hold off a couple of years, because if there's production, that number is going to jump quite a bit. So on the flip side of it, I'll tell them that too if I think the bonus is too low.
Cautionary discussions, so
Yeah.
you put that information in writing
Absolutely.
and have them sign an acknowledgement?
CYA, my friend, I back that up and put it in writing. Yeah, because clients, we've seen it happen before. Attorneys get sued for malpractice or ineffective assistance of counsel. At the time they were representing the client, they're probably best buddies, probably talked about bison football, stuff like that, which I find a way to work into every conversation with my clients, apparently. But if something goes wrong and that happens, they say, well, my neighbor just got a $5,000 royalty. You told me to sign it for $1,500. What were you doing? And if I feel it's a situation where I need to document it, I've got one client in mind right now. I made him sign a letter, and I memoed the file, sent him a copy, made him sign for it, saying I thought it was way, way too low, and he recognized that I advised him to that. Yep.
Josh, regarding express and implied covenants in a lease, I've seen language in some oil and gas leases, and I don't remember verbatim what it said, but essentially it said that to the effect that there are no implied covenants covered by this document and all covenants are express.
Yep.
Does that indemnify the oil company and get them out of implied covenants? Does that hold water,
I would think so. Yep. And I know there's a case out there. I don't think it's from North Dakota on it, but I know one of the oil companies I've worked for, I start putting those in there just because you don't want it to become an issue, because of what's happening. A lot of minerals or owners are using it for leverage to negotiate by kind of gunpoint, so to speak, saying that even though I've had this well producing on my land for 20 years, I've been paid for it, it's not enough. I think if you put language in there saying, mineral owner or lessor expressly disclaims all implied covenants, the covenant of, and I would go as far to list them, including but not limited to the implied covenant of reasonable development, against drainage. Yeah, I would think any court in North Dakota would uphold that. I can't guarantee it, I'm not a judge, but I would think that, obviously, I would think that any court would uphold it.
It's still prudent in drafting a document then?
Yeah, absolutely. Yep, and that's something too that these documents control. Especially these judges in western North Dakota, they're very versed in this area, and they know what's going on. If you can put something in an agreement, it'll control whether it's fair or not. A situation that comes to mind right now, I just had a case we had to settle my client, and I didn't represent her the first go around through district court. It went up to the Supreme Court, then went back to the district court. Her family owned all the minerals, right? So the attorney, and I don't know who the attorney was, who drafted the contract for deed, they wanted to sell the property, just the surface. So they did that. They had a contract for deed, and they sold the surface of the property. Okay, that contract for deed is paid off. So once it's paid off, you have the warranty deed, right? Well, for whatever reason, the attorney or whoever drafted that warranty deed reserved only half the minerals. They reserved minerals. They shouldn't have said anything about reserving half the minerals. They should have just let what was in the contract for deed control. I don't know if they tried to get fancy or if they thought, well, let's tweak it. But when they said we reserve half the minerals, what happens to the other half? Conveyed it, exactly, went to the surface owner, and the judge said, there was evidence. No one said that, well, they paid more, right, under the contract for deed. Let's say it was, I can't remember how much it was, but let's say $80,000, and they paid the 80. There was no greater consideration. They didn't give anything else. But when those deeds are unambiguous and clear, they're going to control. Unless you have something, you have to bring the big guns to show that wasn't the intent of the parties. And there aren't many cases out there where a court said, this document says X, Y, Z. It's clear it says X, Y, Z, but we're going to read A, B, C, and D into it. So if you have that document, if it's in writing, you're in a pretty good spot, I would think. Yep.
A question. You might be able to clear me up and give me some just general background, but in dealing with leases that you covered here today, there's certain rights, but it sounded like it was more like how much are you going to get paid and what's your royalty, besides all the fine print. And then
Yep.
you use the term working interest.
Yep.
And I'm thinking, does that arise out of a lease or does that arise out of somewhere else? And can you
Yep.
explain that?
The concept is separate, okay? So let's say you have the minerals, I'm the oil company, and you have all the minerals. And I say, I want to lease those minerals from you. And you do a lease, so when we say 20% royalty, you're not getting, you have an interest in all the minerals under the ground, right? Okay, when you sign that lease for a 20% royalty, because I'm the one who has the capability to drill and get that oil out of the ground and the mineral owner doesn't, there's a cost associated with that. So I say, I'll give you a 20% royalty if you let me take all your oil, right? A working interest is a separate and different concept. In that case, you say to me, well, I don't want a lease. I want to be your partner. I want to take a working interest. And you're allowed to do that. If you own the minerals, you can take a working interest. So let's take that section 1 and 12, right? 1,280 acres. Let's say you own 280 acres, right? That's I'm not a math guy, but I think that's 1/10. And if it's not, let's just assume it's 1/10. So you own 1/10 of the minerals in that section. I try to lease them. You say, oh, I want to be your partner. I want to take a working interest. So let's say it costs me $10 million to put that well in that section. You're going to pay 10% of the cost for that well. So you pay that $1 million to drill that well, but now you get 100% of what you're entitled to instead of that 20%, right? So that's the difference between a working interest and a lease. The working interest is obviously a lot more capital intensive, and a lot of folks just don't have that money laying around to write a $300,000 check to become a working interest owner and take the share. So it's not, and I should be careful with the terminology I use, because even though it's a lot like a partnership or a joint venture, when you become a working interest owner, there are these joint operating agreements that govern, and they're very, very clear to say, even though it looks like a partnership, smells like a partnership, it's not a partnership. So.
And when you say 100%, if you're a working interest, you get a bigger percent, but it's really not 100% because you're probably sharing it with someone else, right?
Well, yeah, it's 100% if you own 100 of those, all 100 of those mineral acres. So let's say, going back to the homestead, your great-great-grandpa, he owned all the minerals, and it went to your grandpa, then to your dad, to you, and it wasn't split up between anybody else. Well, if you own that 10% in and of yourself, then you get all of it, all that 10% that comes out. But you're right, and that's a good point. A lot of times it's a lot more chopped up. So your predecessor in interest may have owned the 10%, by the time it got to you, you might have like a 1/8 in that 10%. Yeah. The Pew clause there, you can't use it during the primary term. So if you have a 5-year primary term and you've got acreage in section 28, nothing's going on, but there's production or operations on 1 and 12, that Pew clause only kicks in at the end of the primary term. Yep.
What's your interpretation of requesting damages if certain provisions aren't followed in a lease?
And that's a good point. When you bring a claim for breach or for damages, I do that all the time for clients. Usually it relates to the fact that I don't think there's been production. Well, I know there's been production. I don't think there's been operations. We're going to sue to have the lease forfeited. I think if you feel there's damages, you should absolutely make a claim. But as far as specific damages, was there a certain area you were talking about or questioning about?
Well, like for pipelines or if some provision of your lease isn't followed to actually be able to get a damage in a dollar amount.
Oh, so if you say something like you can't do X and then they go ahead and do X. Yeah, I would think that my guess would be the court's not going to have them go back in and take it out, because that would, if you're talking about a lot of infrastructure, putting in pipelines, court might say, yeah, well, we're not going to make them do specific performance, but that has a dollar value of this. I think it would be very factually specific what a court, if it went through litigation, what a court would do. I think in most cases they'd probably try to put a dollar figure on the damages rather than order specific performance. But if it's a situation where, and I haven't seen any of this, but a situation you might be talking about, you say, you know, I've got this pasture out there, I run my horses, I don't want them to put any infrastructure or access or transmission lines out there. Well, they do, and you find out they do, and so you sue for that, you sue for damages. That might be a situation where they have to do specific performance and follow with the terms of the lease and take that down. But yeah, you can there's nothing stopping you from bringing a claim, might be the easier way to say it. It would just depend on the facts, whether the court would make them perform or whether the court would just say they have to award you a dollar amount on damages. But I don't think it's going to be, you know, it's not going to be like $1 million, $2 million, $3 million. I think the damages are going to be a lot lower than that. But as to what they would be quantified, I think would be a case-by-case type thing, which is maybe a real roundabout way of saying, I don't know. It's a good question.
Besides that bonus, can you comment briefly on the royalty rate? You know, they started out around 12, those old leases, $50 an acre. Now it's up there.
Yeah.
What's the max?
What's the max? Well, I've heard that there are bonuses that are going from anywhere to $3,000 to $5,000 per acre, but that would have to be in a really, really hot area of production, and that well has to be, for whatever reason, the oil company's thinking that bad boy is going to produce us all kinds of oil. I hate to call it market. I think what we're seeing now, what I'll say is that in my experience, as oil companies come in with an offer, and a lot of those offers tend to be in the same area, at least the initial ones, and kind of the average where there's production or where there's exploration, the bonuses now are tending to be $2,000 per acre, and the royalty is about 20%. That's in a good area. I think that's what we're seeing as far as the initial offer in a good area, but you can obviously negotiate for more. In other areas where the production's not as great, or they feel it's more speculative, or they just want to make a lower offer, I mean, we see $1,500 all the time and 18.5% royalties, but it all varies. It depends on where your acreage is at compared to the known oil and gas. It depends on how much acreage you have. The more acres that you have, the more leverage you're going to have. So let's take again that section 1 and 12 in that 1280. If you own 320 acres, you're going to have a heck of a lot more leverage to negotiate better terms than if you own 3 acres.
Okay, thank you, Mr. Swanson. Let's break for lunch until 1 o'clock.